Hi, very good morning. This is a judgment of Delhi High Court on the issue of e-way bill. The citation is Kamal Envirotech Private Limited versus Commissioner of GST. So there are three writ petitions. I think two writ petitions. Uh, the allegation was goods were transported under incomplete e-way bill. Part B was not filled or it was missing. So department imposed section 129 penalty and the order was confirmed. Appeal was filed by the assessee, which was dismissed. Hence, a writ petition was filed before the Delhi High Court. The contention of the department was that penalty can be imposed even in the absence of mens rea or fraudulent motive or intent to evade tax under section 129. They said section 129 is a penal provision, so it contemplates a levy of penalty statutorily. So it must be levied. That is the contention of department. The contention of the assessee was it's only a minor breach. So the maximum penalty that can be levied is only 10,000 rupees under section 122. So they said the principles given under section 126, general principles for levy of penalty, that will apply and not section 129. High Court noted Delhi High Court noted that penalty under section 122 and 124, the entire penalty provisions they discussed. Uh, Simply put, they said section 122 and 124 gets attracted only in case of infraction of statutory obligation and conditions imposed. Penalty under section 123 will get attracted on failure to reply to a notice. Section 125 is a general provision. Wherever there is violation of provisions of the act or the rule, wherever no specific penalty has been provided, section 125 will get attracted. Section 126 states the principles governing imposition of penalty. It says, being an important section, I want to just a little bit explain this section. It says, as explained by the court, it says for minor breach, contravention of procedural requirement, omission or mistake in a documentation which may be rectifiable and all of which might have occurred without any underlying fraudulent intent, or if it is the outcome of gross negligence, it mandates the officer to desist from imposing the penalty. Section 126 uses the words that no officer shall impose and penalty imposed under this act shall depend. These are the important words in that section. It is a clear indication of legislative mandate. The officer should bear in mind the gravity or severity of the breach, an intent to evade tax, fraudulent conduct, and remove from it mistakes of a minor nature, and failure to comply with the procedural requirements, or commission of a mistake in documentation which is rectifiable. So you have to bifurcate. Is there a fraudulent intent? Is there a intention to evade the tax, etc.? You should see. Or it is only a violation of a minor nature. The officer has to bear this in mind while imposing the penalty. Section 126 also says that a minor breach would be an amount of tax which involves less than rupees 5,000 and that an omission or mistake shall be considered as easily rectifiable if the same is apparent on the face of record. So that is also said by section 126. Section 126 also enjoins that the officer should bear in mind that penalty should be imposed based on the facts and circumstances of each case and must depend on the gravity and severity of the breach. This is in detail, section 126 is explained because it is the principles governing imposition of penalty. After going through it, court says you have to bifurcate between minor breaches and breaches of such nature where there is a fraudulent intention to evade the tax. Simply put, the court said that it was unable to agree with the department's contention that the levy of penalty under section 129 is statutory in nature. Court noticed the distinction between provisions that impose a penalty mandatorily and cases where discretion is given to the authorities by prescribing a maximum penalty. So this is the maximum penalty. You see the nature of the penalty, you impose according to the gravity of that breach committed. Department contended that the non-option clause in section 129 overrides all the other provisions of the act imposing penalty. The court negatived the submission, stating that it will ignore the clear legislative intention. Court examined the expression contraventions of the provisions of the act under section 129, whether that will also extend to minor breaches, mistakes, or omissions, which could be said to be easily rectifiable or untainted by fraud. Court noted section 122, which deals with supply of goods without issue of invoice, collecting tax but not depositing it, tax deducted but not deposited, utilization of ITC without actual receipt of supply of goods or service, refund fraudulently obtained, failure to take registration, falsifying the books of records. In the view of the court, these violations cannot be considered as minor violations. The court held that the expression contravention appearing in section 129, it has to be understood bearing in mind the special provisions which are contained in section 126, that is the principles imposing penalty for imposition of penalty, which indubitably carves out an exception with respect to minor breaches as well as mistakes and omissions which could be easily rectified. So it's clear. Somebody falsifies his records, or somebody is not taking registration but going on collecting tax, collects the tax but not depositing. These are not minor violations according to the court. Even the Central Board of Indirect Taxes and Customs understood section 129 in the same way. That is what the court says. Section 129 principally covers the release of goods and conveyance which was detained or seized. It is not controlled or regulated by any other portions of the Act. The non-option clause appearing in section 129 must be construed in that light only. Because the submission of the department was the non-option clause appearing in section 129 will override all the penalty provisions, which was not accepted by the court. The court negatived the submission that section 129 intends to override section 126. That is the principles governing imposition of penalty. Court held that such an interpretation would amount to depriving the person the benefit of the principles of moderation, which are enjoined in that section, which should be borne in mind while imposing the penalty. By excluding fixed penalties from the scope of the section, the law ensures, that is the penalties which we have seen, failure to take registration, collecting the tax and not depositing it, etc., etc. The law ensures clarity and consistency in its application, underscoring the principle that certain penalties are non-negotiable and uniformly applicable irrespective of the circumstances of the breach. The court noted the judgment of Gujarat High Court in Synergy Ferticum, wherein it was held, confiscation is penal in nature and should only apply in cases where there is a clear intent to evade the tax, as opposed to mere procedural lapses. That is the judgment of the Gujarat High Court. Is there an intent to evade the tax or not? Is it a minor breach or not? These are the two questions which has to be addressed by the department. The court was in complete agreement with the view expressed by Gujarat High Court that harsh consequences that follow confiscation warrant that provisions of the act must be interpreted in a fair and reasonable manner. Otherwise, it will attract the Article 14 of the Constitution. The court said, in any event, Section 129 can neither be construed as envisaging an inevitable levy of tax or imposition of penalty. You cannot say all the circumstances I will impose penalty under section 129, which generally department is, as of today, it is levying. The court was of the opinion that the levy of penalties under the Act must be guided by the principles enshrined in section 126. That is, that section says principles for imposition of penalty. The statutory provision is undoubtedly an embodiment of the legislative intent of levy of penalties being guided by the principles of moderation, restraint, and reasonableness. So every case has to be examined on its merit. See whether there is an intention to evade the tax or it is only a minor breach. The department has to conduct this and then apply their discretion if it is a minor breach and then impose penalty according to the gravity of the nature of the breach. That is what the court says. The writ petitions were allowed and orders imposing penalty were set aside by the Delhi High Court. I thought this because e-way bill authorities are regularly imposing 129 penalties without seeing the gravity of the nature of the uh, violation and then imposing the maximum penalty and levying tax and penalty also. So I thought it will be useful for the business community and the professionals. Hence, I am sharing this judgment. Thank you very much. Have a great and wonderful day.